this past March marked not only 1 year of the pandemic, but also it's been a year now during which nearly all jury trials in civil cases have been postponed. So certainly now more than ever, parties in litigation have been using what's called alternative dispute resolution. Here to give us a basic overview of ADR, attorney Tom Sinus of Sinus Dramis Law Firm is joining us as he does every week. Tom, what is alternative dispute resolution and what are the basic forms of it?
It's a great question because you're right. In civil cases, which involves all of my practice, we're seeing a lot more use over the years, but particularly over the last year in what the abbreviation is ADR, alternative dispute resolution. And what that really means is resolving your case through some way other than a trial, other than a jury trial or a bench trial, which is a trial conducted by a judge. And in Michigan, there's three of the most common types, and it's confusing because they kind of all sound the same. They all end with ION, and they have a way of blurring together. The first is what's called mediation. And mediation generally is a concept where the parties voluntarily get together in a confidential process, and they choose a neutral third party to act as a mediator to see whether that third party can bring the parties together towards a voluntary settlement. Then in Michigan, we have a process that is not all that common throughout the United States, and it's called case evaluation. This is a process where generally a panel of 3 lawyers convene and they review both sides of the case. So they review written materials, they review oral arguments, and then this panel of 3 attempts to reach a unanimous decision about what the case should resolve for. And each side then has an opportunity to either accept or reject that panel's decision. And then lastly, people hear commonly about a form of ADR called arbitration. And arbitration takes on many different forms, but the distinguishing characteristic of arbitration is that someone else, it could be one person, it could be a group, those people or that person makes a decision about the case, again, outside of the courtroom, and the decision that that person makes is binding upon everyone involved in the lawsuit. And so those are the 3 basic types.
3 basic types. Which of those forms of ADR are binding and maybe which are not?
Right. So arbitration generally is binding, and people see the arbitration clauses, in their credit card contracts, in their contracts to buy a home. So there's a lot of forms of binding ADR in the form of arbitration that people may not know. So that's the most binding. Case evaluation can be seen as somewhat binding because there can be negative consequences for the party who doesn't accept that panel's decision. They can actually be forced to pay the other side's lawyer fees. So though it's not binding, it has consequences. Mediation is the one I think that most people would call the most voluntary because you're usually there. Maybe the court told you to go, but if you participate in the process and you settle your case through that process, the decisions that you make there are usually entirely voluntary.
All right, Tom, a lot of information there. Where do people go to get more information from you?
They can find us online at www.sinusdramis.com. They can shoot us an email at info@sinusdramis.com or give us a call, 616-301-3333.
All right, good stuff as always. Thanks, Tom.
Thanks, Derek.